the Court of Appeals decision, why was not published?
Thank you all. Please be seated. Good morning. This is the time set for oral argument in our case number CACB 20-0535, Todd Eric Borowsky versus Alexis Brooks et al. Counsel, good morning. Each side does have 20 minutes to present oral argument this morning. If appellant wishes to reserve a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time, and it's a little more complicated with the courtroom setup today, given that clock is a little bit distant. And with respect to appellees, we will defer to you as to how you allocate your time. There are two appellees that have oral argument for today. Please keep in mind that our proceedings are being recorded, and as you present argument, please do start by sharing your name and the party that you represent. Now, to courtesy to everyone here and respect to counsel, I would ask that you make sure those cell phones are off to avoid embarrassment and avoid interruption with our proceedings today. With that, Mr. Wolinchek, you may proceed.
Well, thank you, Your Honor. Good to see you all today, healthy. Your Honors, we're here, as you know, to seek reversal or remand of summary judgment motions based on the fact that there are material factual issues in dispute. And to cut to the heart of it, we find ourselves in kind of a difficult situation, as I think the court can appreciate, because it appears to us that this ruling, best we can judge it based on what was presented to the court, was based on the prior dismissal of the count 1 claim regarding illegality of the original loans. And
counsel, that's the June or July 2019 ruling, is that?
Yes, Your Honor.
Okay, thank you.
And so what I'm getting to is that it's a little difficult here, I think, for all of us, because the court refused for whatever reasons. I was not, as you know, the attorney below, but the court refused for whatever reasons to grant Rule 54B final judgment on that, as a result of which granting summary judgments essentially on these motions, which were principally based upon count 1, as was our motion for new trial, it would, in my opinion, create inconsistent rulings, to say the least, for this court to now rule on these motions without remanding to the court to enter final judgment, because if that issue comes before the court and the court does find that these were illegal loans, then obviously it changes the whole ballgame. So starting off, it's a very difficult situation here, and frankly I think that's why, in my judgment, this needs to be remanded back or stayed or put back with an order to the court remanding it, saying, you know, enter final judgment on that, and then you should go up at the same time on the same issues of the illegality.
I understand what you're saying,
yeah.
And you know, although we are an appellate court as of right, and we take the cases
yeah.
as they're presented to us, I understand your point about that count 1 decision, the July it was, 2019 minute entry, has not been subject to, or at least a partial judgment has not, making that appealable, has not been entered. But again, we take the cases.
But no, I completely understand. But I guess my point is, given that situation, it clearly would create an inconsistency if the court didn't remand it to put it all into one package. Because again, if that ruling is ultimately reversed on the illegality, it would directly affect the arguments being made here that were made below that caused, in my judgment, the ruling on these summary judgments to be granted. Because there are clearly material issues of fact, numerous material issues of fact, on whether or not Hurwitz was a partner based on his own admissions. If he's a partner, there's issues, as you have before you now, as to whether or not he's bound jointly and severally to the actions of his partner Brooks. There's issues on whether or not Alexis Brooks is a front person, straw person, whatever you want to call it, for Mark Brooks. There's inconsistencies with her position on that and Hurwitz's position that he was the partner of Mark Brooks without any mention of Alexis Brooks, and other testimony that confirms that as well.
Counsel, let me ask you,
Yeah.
it does seem in some respects that the appellees here,
Oops.
and please,
Sorry. I'm used to leaning on that thing.
we're doing what we can. I think it is backing away. If you just drop it down with that lip over the top.
Okay, I'll leave it alone.
We'll help for the best.
Right.
How about that? And please, for all counsel, acoustics are somewhat different, so if you can't hear, please, and want to be hearing, please let us know. But it seems like, in some respects, the appellees are dissimilarly situated, Mr. Hurwitz and Ms. Brooks, and I want to talk about that in a little bit.
Dissimilarly situated from who? You mean Mark Brooks?
The arguments that are being made are somewhat different, and I'll
Okay.
hear, I want to hear from you on that. But before we get to that, it looks, from the review of the record, that there was no statement of facts that disputed the movant's statement of facts in support of the summary judgment, and this separate statement of facts offered by Mr. Borowsky wasn't signed by anyone, particularly Mr. Borowsky. And I wanted you to address those two
Okay.
issues, which seem atypical under Rule 56.
Okay, sure. Let me start, I guess, with your first point about the separate statement of facts. First of all, the only statement of facts, I think we pointed this out, the only statement of facts that was really sort of anything that could be a disputed fact, because the other statement of facts that they had, I think there were 3 of them, if I recall correctly, dealt with just reference to documents which aren't in dispute, dealt with whether or not Hurwitz was involved in the investment, as I recall, to go to your question. And, whether he was involved in the investment or not, frankly, is of no moment to the ultimate issue to be decided, particularly as to the count 1 issue, or any other issue, because as a partner, and we cited all this law, which I can, regurgitate, but as a partner, you are responsible. That's the whole point of being a general partner, for the other partner's actions, whether you like it or not. And so the 33 separate statements of my client do effectively controvert that point to the extent it needs to be controverted. And secondly, I think we cited also...
Can I stop you just there? I think if the controverting statement of facts, or the separate statement of facts that Mr. Borowsky purported to file was properly authenticated, properly verified, I understand what you're saying, but I'm not sure that was the case.
Okay. Yeah, let me get to that. I'm trying to find my notes on it, but my recollection is, maybe you can find it for me, that what happened is that I think we cited a case, and that's what I'm trying to find really quickly. But the sworn complaint itself, which is verified, as I recall it now, would effectively accomplish the same end as an affidavit. There's nothing that I'm aware of that specifically requires an affidavit as opposed to a sworn, I think it's a Corbin versus Sable case, if I recall, which was cited at pages 8 through 9 of our reply brief. And we contend that based on that case's authority, the verified complaint should be considered equivalent to an affidavit on summary judgment standards. So I hope that answers the question as best I can answer it. But getting back to the point, I understand, and I really want to harp on this.
Let me ask this then. Would it comply if the allegations in the complaint are specific? That on this date and time, with respect to this transaction, these things are what I believed them to be, and then sworn by Mr. Borowsky?
Yeah, I think so.
Okay. As opposed to an opinion about, I think he was,
Yeah.
whatever the case may be.
Well, I think, to answer you honestly, any conclusory statement in a complaint probably wouldn't comply with Rule 8 anyway. And so that's the best I can answer that. But I don't think we're dealing with that here. I think in fairness, we're dealing with sufficient allegations in the complaint that would essentially amount to a facilitation of this loan transaction by both of these folks, the appellees, and as a result of which allowing Mr. Brooks to again, perpetrate what we believe to be an illegal transaction, but more importantly, a transaction that ultimately led to a scheme, if you will, to make loans in cash and to basically bait and switch people into thinking it's being made by a lawful company. And in fact, at the last minute, it's made by him in cash, and he requires payments in cash, and then later to claim that he doesn't receive these payments and wrongfully foreclose on the collateral.
Before you go on too far, Counsel, I just
Yeah.
wanted to make sure I revisit the question about using the complaint to survive summary judgment. At that point, then, the complaint has to be pled with sufficient specificity to constitute basically a response to a motion for summary judgment, statement of facts, not just the plain and simple statement that, oh, I've got this complaint, I've got that complaint. Would you agree?
Yeah, generally, I think I would agree with that general statement.
Pleadings to allow it to survive summary judgment.
Yeah, I would generally agree with your statement. But I think that again, I don't think that's the basis upon which the court even ruled in this case, to be candid.
Well, and it's, in that respect, it's a little terse, isn't it?
Yes,
The
it is.
basis for the ruling.
All I can say is that it appears, based on what I see in the record, that that became the focal seminal issue in the case, that the court had already ruled it's not illegal, and therefore their participation in this, what I'll call scheme, could therefore not be illegal also. And again, you're right, it's very terse, but I think that's pretty much the basis. I don't think he did an analysis that I could find of whether there are actually facts in dispute based on this issue of that Judge Gass is raising. Now, I don't see that. There clearly are sufficient facts to raise reasonable inferences to a jury about the inconsistencies in both Hurwitz and Alexis Brooks's positions alone as to whether or not this 22-year-old person is put into a company. She gets nothing out of it, gets no money out of it, claims under oath that she's not involved in anything involved in the company. Then why is she involved in it?
Counsel, let me ask you, with respect to Ms. Brooks, I've read the briefing in front of the trial court, again, not from your hand, but from a predecessor, and it seems to me to say, hey, if given that July 2019 minute entry, we're done. We've got nothing to say. And so as long as that July 2019 minute entry is in place, we agree summary judgment should be granted in her favor. And here we sit in October 2021, and that same minute entry is in place. How is that not a waiver of that argument?
That's a great point. And again, I don't think that's an admission by Mr. Tully as I read it. The same thing that you're reading. I didn't read it the same way. What I read is that Tully is practically saying to the judge, look, we understand that's the basis of this, and that's why I keep saying this. You've already ruled that. And so while that ruling is in effect, and meaning while it's a valid final judgment, essentially, that's how I read it. I know you may disagree, but that's how I see it. Obviously, there's nothing to talk about, which is my whole point here. The problem I've got is, again, the way the judge structured it then, I'm not saying he did that purposefully in response to that point, assuming that he agreed with your position. I don't think he was that devious to do that. But the practical effect of that is that by withholding final judgment for no good reason that I can even understand, then he causes this to have to be upheld based on that statement that you just brought out. And that, to me, is not justice. It's not even close to being just. It's a game. And if that's the game, based on what you just said, Judge Thoma, then it's wrong. And the court needs to remand it and say, look, enough. Make a final judgment. There's no reason why it wasn't a final judgment. I can even fathom in my 43 years of doing this, other than to effect an unjust result that you just posited. And so we're either going to handle this all at once and determine whether, if that's the basis of your ruling, this was legal or illegal. But frankly, the mere fact that the loan was legal per se does not end the inquiry from our standpoint here. I believe that there was certainly, regardless of whether the loan was legal or illegal, a scheme, a partnership beginning with Hurwitz, which he's responsible for the acts of his partner, and an aiding and abetting of putting a front person in to legitimize auto title loan and keep him out of it as a convicted felon, and then him to take all the benefits and to lead people to believe that auto title loan is involved, and then at the last minute switch them and say, well, we're down to the wire, you don't get your loan unless it's Mark Brooks. And what are you going to do as a consumer at that point when you're ready to sign? So the whole scheme has nothing to do with whether or not ATL is making a legal loan or not. Ultimately, it was Brooks that made the loan. The question is whether or not this scheme of these folks is appropriate, and whether that the scheme to ensnare someone into this loan and to wrongfully foreclose and then put him in jail over this scenario for 58 days, claiming that he shot at them, which was ultimately dismissed by the county attorney as being baseless.
Let me ask you,
Are they responsible or not?
and I'm sorry to interrupt, but
Sorry
let me
to-
ask, with respect to Mr. Hurwitz, claims against him were resolved in sort of two tranches. One on the motion for judgment on the pleadings, that as I read it, resolved everything but the contract and good faith claim.
Correct.
And I read your briefs as challenging the determination on the contract good faith, not the remainder of those.
Well, and that's a great question, and candidly, and the problem with it is just as equally candid. I don't think we could appeal those. I think the time ran for those long before I was involved. So, quite honestly, I don't think we had the right to do that. So the only thing we're left with is the contract claim and the bad faith claim. And the best I can say on that, again, being simple to the point of being direct, is as a partner, we're not going to take the time to go through it all. You have it all. I think they have the partnership law just wrong, and clearly misstated the partnership laws. A partner is responsible and for another partner's actions, and whether, again, they like it or not, and whether they're fully informed or not is a lawsuit against their partner, not a defense to a third party who relies on a loan that frankly is just wrongfully and fraudulently made. Regardless of whether it's illegal or not per se, the whole loan process itself resulted in a wrongful foreclosure and a breach of the peace. And that tortious conduct was also aided and abetted by the fact that, again, the loan would never have been made in the first place had it not been for the involvement of Alexis Brooks as the front person supporting the company in lieu of her father's participation, which she knew he couldn't participate, obviously, or didn't choose to participate as a convicted felon in a licensed enterprise or put his name attached to it. So, yeah, that's pretty much it. And I would just reserve some time here, but I would go back finally just in conclusion to say that, and I'm not going to spend my time on a lot of these other tangential arguments on the sanctions and all that. You know, I've said all I need to say on that, and you have all the emails, and you can read them yourself to see if we acted wrongfully or in bad faith. I think that's an insult. We absolutely did not. We absolutely would have withdrawn that untimely appeal that was filed by mistake, honestly by mistake by someone in my office. But they jumped the gun and filed this long thing and then blamed us for it. Anyway, let me just end by saying this. I do believe that it makes the most sense, notwithstanding what you said, Judge Thumb, and I understand completely your point, that you have to, deal with the hand you're given. But the reality is that that hand includes the fact that that illegality issue is not final. And if that's seminal to this issue, which I think it is, I think the court has to assume, because it's not final, that there's no final judgment on the illegality, and therefore the rulings on these summary judgments, if based upon that, which it appears to be, must be remanded and reversed. And we'll be back here again, I suppose, if that happens. Thank you.
Thank you. Mr. Klain, Mr. Stanley, how have you decided you're going to allocate your time?
Good morning, Your Honors. Bill Klain of Lang & Klain. I represent the appellee Alexis Brooks, who's with us here today. Also with us, my associate Brian Puderoy. And may it please the court, I'm not sure why we're here today. I understand in a practical sense we're ordered to be here for this argument, and I think I asked for it. But two questions kept popping into my head. when I was working on the briefs, when I was working on a reply on summary judgment below, and when I was preparing for this argument. Number one, why are we here? What are we doing here in light of the concessions that have been made? And number two, what questions of fact were created or demonstrated to exist by the appellant by competent evidence? I submit to you the answer to the second one is no. Before I get in, I do want to make a point and respond directly to appellant's argument with respect to the claimed relationship between the dismissal of count one, which was not asserted against my client, asserted against defendant Mark Brooks, who's not before you on appeal. 2 counts asserted against my client: racketeering and aiding and abetting facilitation under ARS 13-1004. We wrote in our reply, and this is in the index of record at 154 at 7, even if her father's loans to plaintiff might be found on appeal to have been made in violation of Arizona lending laws, the loans have nothing to do with Ms. Brooks or ATL, and Ms. Brooks' activities relative to ATL could not be found to have caused any harm to plaintiff. Reversal on appeal as to the legality of the loans would not alter any of this in any respect. You have to show causation. You have to show that you were proximately harmed by the alleged conduct. They conceded in discovery that Ms. Brooks had nothing to do with the loans. She wasn't a party to the loans. They conceded in their discovery responses that ATL did not make the loans. They conceded in their discovery responses that Ms. Brooks had nothing to do with the repossessions. So if you buy, and it is disputed by competent evidence, which wasn't controverted by competent evidence, but if you buy the notion that somehow Ms. Brooks was acting as a straw person to disguise her father's interest, claimed interest, in ATL, if you're willing to go down that rabbit hole, it was not the proximate cause of any harm to the plaintiff, nor could it be.
Mr. Klain, let me
Yes, sir.
ask you, isn't proximate cause almost always a question of fact?
Unless you have
Fact
no,
finder?
yes, Your Honor, unless you have no evidence. And there is no evidence. When you look at what was presented, the summary judgment record, and getting past the concessions, 5 times conceding that the motion should be granted. I mean, just taking that, and I'll come to your question, what is a trial court judge to do when the party opposing summary judgment says the motion should be granted? 5 times in their brief. I submit that the judge should not send those claims to a jury in the face of those concessions. But as to the evidence that was presented, you have bank statements showing where the money's flowed to, Alexis J. LLC, owned solely by defendant Mark Brooks, not by my client. We submitted under seal Ms. Brooks's bank statements, showing what you would expect to see for someone who at the time was working as a PD, a young first-year PD, no anomalous transactions, no inflows of money. And we traced the checks that were given and showed that they went into the LLC's account. That's undisputed evidence. That's competent evidence. What do you have on the other side? Disputed. Disputed. This is only supported by her self-serving affidavit. Well, it wasn't. Most affidavits or declarations tend to be self-serving in my experience, but it was also backed by properly authenticated banking records showing where the money went. They came forward with nothing on the other side. When you look at the complaint, the verified complaint, which this court's case law holds that a verified complaint is not sufficient to withstand summary judgment, to create a question of fact, and that is the Nations Bank case, Your Honors. When you look at the verified complaint, even if it could create a question of fact, which this court's jurisprudence says it doesn't, the only thing in there that's remotely close to a fact is a blend of conjecture and fact. Appellant claims he witnessed a conversation between father and daughter where he showed her allegedly a bank account statement in her name and said something to the effect of, "Look, honey, you're a millionaire, almost a millionaire." And she said, "Dad, you know that's your money." Well, we've shown her bank accounts. But he didn't come back with anything. Now, what does he do with that conversation? Which really goes to prove nothing, okay? He says, well, she must have known that her accounts were being used. That we get into conjecture. That we get into speculation. That we get into no personal knowledge. That's what we get to. He's drawing an inference, an unfair inference, in light of the evidence presented to the court. But that's it. That's what's in front of Judge Martin when he makes his ruling. So to suggest that Judge Martin's ruling was dependent upon the dismissal of count one and that everything hinged upon that, I submit to you that's not the case.
Counsel, let me ask you, in looking at the record at least, Mr. Borowsky's then counsel viewed it differently than what you've just described. Not maybe a shock, but that July 2019 ruling, which has some significance in this case, at least to some parties in this case, has not been reduced to a partial final judgment, is not, as we know from the original opening brief in this appeal, is not part of this appeal. What are we to make of that? And I understand your view is that that's irrelevant from your client's perspective, but if we took a different view, what would come of that? Is it a series of Rule 60 motions if that somehow is changed at some point in the future, given that we're dealing with partial final judgments here?
Well, Your Honor, I think the answer and is why was Rule 54B language included in these judgments? Because two claims asserted against my client, not dependent upon count one. My take, what I argued, I understand they tried to reframe my motion's argument, concede it should be granted, but tie it to one, and I argued back, no, this is not tied to count one. So we don't know why he will, but in the context of the entry of the Rule 54B language rendering these judgments appealable, you had a party against, in a 14, I want to say a 14 count complaint, two claims asserted against my client, Alexis Brooks, resolved as to her. So is she going to hang out with the cloud of litigation over her, potentially exposed to expense for years as the rest of this case works its way towards trial or ultimate resolution? No, that's what 54B was there. All issues as to that party were resolved. And I think we're perhaps trying to read tea leaves, or I would suggest that it is an exercise in tea leaf reading, to say, well, Judge Martin really hinged this on count one, when the record before him reflects that it was argued. Count one has nothing to do with the viability of these claims. Now, again, appellant tries to reframe that, and I understand why. And so what do? I reply to that argument, or Ms. Brooks replies to that argument and says, no matter what you do, given their concessions on count one, it doesn't affect her. I see I'm almost out of time, and I want to make one more point. You heard appellant's counsel talk about this notion of a partnership, okay? None of that pertained to Alexis Brooks. I'm sure they will be addressed by my co-counsel. We've agreed to evenly split the time. But none of that related to Alexis Brooks. She was a member in an LLC, ATL, Auto Title Loans USA LLC, as it's affectionately formally called. Mr. Hurwitz was another member of that LLC. She is not liable for his separate activities, A, that didn't involve that company, which they admit didn't make these loans, or B, under a very different liability, shields from liability, as between partners in a general partnership, which she is not alleged to be a member of, and an LLC. She is a member-member relationship with the other member. Very different. Now, I didn't have to argue the finer points of piercing corporate shields to get to liability of the underlying shareholder, member, partner, because it was never argued as to my client. And I think that's important to note here. My client and Mr. Hurwitz are in different seating, and I suggest nothing by that other than the arguments that were made relative to partnerships that don't apply to my client. If there's no other questions, and out of courtesy to my co-counsel, I think I'm going to sit down and reserve the balance of our time for him.
Very well.
Thank you, Your Honors.
Mr. Stanley.
Good morning, Your Honors. I'm Edwin B. Stanley. I'm counsel for David Hurwitz in this matter. Mr. Mr. Klein has alluded to, the substantive position between his client and mine are substantially different here. As the court has pointed out, the bulk of the claims in this case were dismissed against my client in response to my motion for judgment on the pleadings. And all that was remaining were 3 contract-based claims, which were resolved on summary judgment. The appellant has not brought up any argument that the motion for judgment on the pleadings claims should in any way be upset on this appeal. So we're really only talking about why my client received summary judgment on the contract-based claims. And I'll dispute what Mr. Willinchek has said, because as we look through the papers that were filed and the arguments made with regard to that summary judgment motion, there's no reference whatsoever to the dismissal of count 1 and whether or not the loans in questions were legal or illegal. It simply came down to, was David Hurwitz a party to this transaction? And I'll submit that the Superior Court was right in finding that there is no triable issue of material fact that would point a jury in that direction. And I've made multiple arguments on the legal issues, and I think the most prominent one here is the fact that the parole evidence rule applies to contracts in Arizona. It's been picked away a little bit under the Darner line of cases and stuff, but it's still there and it's still in effect. And when you have an unambiguous contract, you cannot change it by going outside of the 4 corners and saying, here's what it really means. And Judge, I'll submit that what the appellant here is suggesting to this court would make a heck of a mess out of written contract jurisprudence in this state. If all you had to do is say, yes, I'm parties, me and him, that's what it says, but that's not really the deal. And the real deal is, let's go off on a magical mystery tour of other things that'll make other people on the hook. And that's what they're doing here, Judge.
Counsel, let me ask you, with respect to your client.
Yes.
There are purported facts that Mr. Borowsky has offered that either purportedly occurred before or at the time the contracts were entered into. And I understand your argument under the parole evidence rule as to those facts, although I'll have a clarification or two in a second. But how does the parole evidence rule affect purported facts or statements or admissions that occurred after the contracts were entered into?
Well, Judge, it still applies because you still have an unambiguous contract. And when the contract is unambiguous, the fact that a statement may or may not have been made post-contract is still subsumed in the parole evidence rule. And I'll grant you, Judge, that they brought up a admissible piece of evidence, this supported conversation where my client said, any time when thanked for the loan. And the 2015 text message, I think it was, where Mr. Hurwitz said, me and Mr. Brooks are partners in the title loan business.
The social media post,
yes,
I think.
Yes, well, I think it was an instant message, but...
Got it.
But, so why do those not create an issue of fact? And before I go there, Judge, I've put this in my pleadings both below and here, is the majority of what Mr. Borowsky has relied upon is hearsay, and oftentimes multiple levels of hearsay, not admissible in trial or in summary judgment proceedings. I mean, my favorite, I guess, was Mark called David and told me that David said. So that's at paragraph 19 of their statement of facts. And Judge, when you're digging that deep past the rules of evidence, I think that the trial court has every right to refuse to to consider that evidence. But as I've admitted in my papers, there's two things that we need to talk about. One is that 2015 instant message where he says we're partners in title loan business. Now, not relevant to establish a partnership in this loan, or in this series of loans, I should say, because Mr. Borowsky, he understood, and you can tell this through his own statement of facts, he understood that to mean that Brooks and Hurwitz had interests in Auto Title Loans USA LLC, an entity not a party to this suit and not a party to the loans, and has never been accused of being a party to the loans. So the fact that Brooks and Hurwitz were, quote, partners in a limited liability company, and I think that there is more of a common usage of the term partner there than what we as attorneys would be comfortable with. But that was said, but the point there is, Judge, it was a year before and it dealt with a different company. And there is no triable issue of fact to make the jump on this record from Brooks and Hurwitz are involved in a licensed LLC that makes title loans to Brooks and Hurwitz are automatically now partners on every title loan that Brooks might do. And in response quickly to what Mr. Milinchik had said, all Mr. Borowsky had to do was say, no thanks. Because he says throughout all this, I didn't want to take a loan from Mr. Brooks. I didn't trust Brooks, you know, the whole litany. And this record, the court has not had the pleasure, I'm sure, of reading everything that's been going on, but there's no love lost between those two parties. And all he had to do was turn on his heel and say, this says it's a loan from you, Mark, I don't want it, and walk out. Instead, he signed the contract and took the money. Now, the other thing that I need to address is this purported conversation at Bourbon and Bones where Mr. Hurwitz was thanked for the loan and said, anytime. And how does that establish a general partnership? And I've taken the court through, and I can today if we need to, the partnership formation prerequisites under the revised Uniform Partnership Act. And that simply does not hit the mark to create a general partnership. General partnership is kind of the residual form of business organization that can be found. But it can't be found here because of all the things. And what's undisputed, and the court had some questions about the form of their statement of facts, but what is clearly undisputed are the statements of both Mr. Brooks and Hurwitz. Hurwitz never got a dime of the payments, never got a dime of the proceeds of the sale of the collateral, had been, I think they dispute this, but had nothing to do with it and didn't fund it. Now, they're claiming that he funded it and had something to do with it, but the fact that he never got any money out of the back end of this is an undisputed fact that in and of itself argues against any kind of a general partnership in this case.
Isn't that something a jury could decide, not us?
Well, but there's...
And if you're asking that to be us to draw an inference from that, an inference is something we don't really, superior courts don't normally do in this kind of setting.
No, I'm not asking for an inference on that, but it's an undisputed fact that Hurwitz never got any money.
Right.
And
you're asking us to draw an inference from that, therefore there's no partnership.
Well, to be a partnership, per the statute and the cases I've cited, there has to be a sharing of profits, a sharing of the business, a commonality of administration of the business, all those things, none of which are shown and none of which is at all in dispute, because the plaintiff and appellant here has put no evidence in the record to demonstrate any of those partnership formation standards. And I'm at 0 on the dot. Thank you.
Thank you, Mr. Sandberg. Will and check. You have about 2 minutes left.
Thank you. I'll be as quick as I can. First of all, it's the right to share profits and losses, not the actual sharing of profits and losses that determines partnership. Let me just hit a couple of quick points in the short time I have. Hurwitz admitted he was a partner, so I don't know what that was all about. In a text message that was attached to the complaint, he says, "Hi, Todd, we met through Mark Brooks. He and I are partners in the title loan business." So, contrary to what was said, that's not hearsay. As far as Alexis Brooks is concerned, I'm not sure what that argument was about either, because the fact that Alexis Brooks was not doing anything in that business is our whole point, contrary to what was just stated. The fact that at 22 years old, she's put in as, I think it was 40%, but don't hold me to that, owner of this business along with Hurwitz, who doesn't even consider her a partner in the business or involved in the business when he's talking. But the whole point is, why is she in that business? Why is she in that business not receiving any money or doing anything that we know of? That is the whole point. That is the reasonable inference the jury can draw. Why is she there unless she's a front person to legitimize this business to third parties? And that's the whole point, and not Mark Brooks. And I'll just be brief on this. The whole point of this is my client didn't want to make a loan with Mark Brooks. The fact that Hurwitz was involved is the whole point to him, and the fact that it was a legitimate enterprise, ATL, he thought, that's who he was going to. And again, I'll repeat, this bait and switch thing, at the last minute, Brooks gets involved with this cash deal. And by the way, I don't know what cash went between these parties when counsel says that there's no evidence of him sharing anything, so he puts all the money up and he gets nothing? The reasonable inference from that is pretty obvious to me, that that's absurd. Thank you.
Yes, please. Thank you very much. We appreciate your briefing. We appreciate your arguments today. We will take this matter under advisement. We'll issue a written ruling in due course. We will now stand in recess as we prepare for next oral argument. Thank you.